Hi, I'm Natalia Angelini.
And I'm Indrita Isai.
Welcome to Helen Estates. You're listening and watching episode number 639. Today, we're going to be discussing an interesting recent case by the name of Winkler and Thompson, and we'll have it up on our website so you can access it there as well.
So I guess we'll start off by going through the facts of the case. It was a really interesting one where I think a lot of good discussion points come on, passings of accounts, the power of attorneys, and sort of the fiduciary duties, and to, always keep those receipts. So I'll get into it.
Yes.
Of course, the testator, Rolf Winkler, he died on August of 2019 at the age of 91. The applicant that brings this application is Ilse Winkler. Is his surviving spouse, but they had been separated for a significant period of time, since approximately 2012. And this application before Justice Penny turned on the question of whether Rolf was incapable in the time period covered by the application. So from May 2015 until his death in August of 2019. Rolf appointed his granddaughter, Crystal Thompson, as his attorney for property in January of 2015. Early in 2015, at the same time, he also opened a joint bank account with Crystal. He shortly moved into a retirement home around the same time. According to Crystal, they agreed she would pay Rolf's bills and she would reimburse herself from the joint account. And this was the arrangement that they had in place. Crystal's position on this application was that although she was Rolf's power of attorney, she did not exercise those powers, if at all, except until the very end. So the vast majority of these transactions were conducted by Crystal simply as a joint account holder and with Rolf's consent. Consequently, she did not keep receipts for every expenditure that she made.
Right, and this is Crystal's brought this application to pass accounts, and she's done that on consent. But the idea is, in her position is, I don't have to do this, right? I wasn't acting as his attorney. I was really, she was acting as his agent because he was capable and aware of what was going on, and what she was doing was, met with his approval. So it's not uncommon that we see in passings this fight over, was she acting as attorney or not? Was the grantor capable or not? And I'll let you delve a bit more into the facts, Indrita, but this is what the court was really wrestling with.
Exactly. So I did want to kind of get into the objections because I always find them an interesting part of passings. So Ilse objected to some various lines in the account. So there was an excess reimbursement to Crystal in the amount of $18,000 and some other expenditures, a cash withdrawal of $4,000, a gift of $10,000 to Crystal for bathroom renovations, certain personal expenditures in the amount of approximately $4,000, Tim Hortons expenses, cash for Rolf's spending. And these were all the various objections that she made. And what do we think about that?
Yeah, and it doesn't surprise me, right? If she was acting as attorney for an incapable grantor and using those funds to pay for her personal items or renovations or whatever, that would be a problem because, right, as attorney, your obligation is to only use those monies for the benefit of the grantor. But in this scenario, this is where, I guess in this scenario, we've got the judge being persuaded that that was not the case. Right, Indrita?
Exactly. Justice Penny ultimately does find that Rolf was capable. And I guess we should maybe go into the analysis that Justice Penny undertakes. So the decision starts off by stating that Rolf's capacity is a threshold issue because there are different duties depending on the capacity of the grantor of a power of attorney.
His Honor was noting Section 32 of the Substitute Decisions Act, which makes it clear that an obligation to keep accounts only arises if the grantor is incapable, or if the attorney has reasonable grounds to believe that the grantor is incapable, which in this case, right, the applicant's position was, well, that's not the case. I didn't have this obligation, and I also, and I don't have perfect records
Mhm.
as a result. And for me, in my practice, this serves as a helpful reminder that, capable or not, if I'm acting for someone who's assisting another with managing their finances, I'm going to be suggesting that person keep all of those vouchers. So if this kind of fight arises in the future, right, that person is better equipped to defend themselves and have all of that evidence intact.
Absolutely. Word to the wise. So I know with respect to his capacity, I think the evidence was pretty interesting into what sort of led Justice Penny to decide that Rolf was capable. So although there was evidence that he was physically infirm and he did suffer from depression from time to time, there was very little evidence of his incapacity. Much of that was being brought forward to say that he was incapable was anecdotal, and that just did not hold the same weight before the court. There were some tests done on Rolf with varying results. The court held that the problem relying on these tests was that they were sporadic and they provided no commentary or analysis about the capacity to manage property specifically.
Right, and that's, I think, critical from the judge's perspective, because it's of such assistance to the court to have that capacity assessment on the question of the ability to manage finances at the material time. And if you don't have that, and instead we've got sort of, this piecemeal evidence that isn't quite fully on point, then it's harder for the court to come to that conclusion, right? Then you've got to pull in a lot more evidence from other areas, like witnesses, friends, family, and that can be a really, time-consuming and costly endeavor. And again, what are we speaking about here? $18,000 worth of objections.
Exactly. So as we briefly mentioned about the Substitute Decisions Act, capacity is presumed. And in the face of the available evidence before the court, Justice Penny was able to come to the conclusion that Rolf did not lack capacity to manage his property until maybe perhaps shortly before he died. So therefore, any of the sort of impugned transactions that took place June, July, or August of 2019 had no bearing on this application. It's for these reasons that the court concluded that Crystal was not obliged to pass her accounts, even though she had done so on consent. And there was nothing improper. That gift to Crystal for the bathroom renovations goes back to capacity. He had, to make the gift.
Yeah, and Justice Penny did in fact pass the accounts, right? Even though she didn't, they were passed, and so matter concluded. And unfortunately for the estranged spouse, she was hit with a hefty cost penalty, which exceeded the amounts at issue in the passing. So that's something that also is another sort of, painful reminder for our clients as to the risks and costs of litigation.
Absolutely. It really, I think, will make people think twice, because that's not an unsubstantial amount, especially the objections are made for things that were really on the smaller scale of things that we may see with respect to objections, and to be hit with a $35,000 cost order is tough, and maybe think twice before bringing a similar application.
Right, and of course, when we've got bigger passings with larger amounts, and these costs can, they can be tenfold, right?
Yes.
So this is a smaller example, but it's still still instructive.
Absolutely.
So unless you've got any other comments, Angrita?
I think we've covered everything.
Great. So this concludes our podcast. Until next time, we want to thank you for listening and for watching. I'm Natalia Angelini.
And I'm Angrita Desai.
Should you have any questions, please email us at info@hollandhall.com or contact us through the contact page on our website. Thank you. Bye-bye.
Thank you.